we have lawyer Alhassan Osman. In fact, last Friday we started a conversation with him. We told him that we'll continue that conversation today on many issues concerning this case. We'll start from this particular issue. Lawyer, good morning, and I hope you're well.
Yeah, good morning. That's the well, so good morning to your listeners as well.
And it's nice to have you on the line. Let's start from this one, because this is and I'm sure your attention would have been drawn to the war of words between Godfred Adami, who is representing the Chief Justice, and then lawyer Thaddeus, who is representing one of the petitioners. And the suggestion by Godfred Adami that he is fighting a righteous cause, the rest are all partisan. First of all, for those who raise issues with the fact that he's seen representing the Chief Justice, that's problematic, do they have a case?
Yeah, well, for those who think that it is problematic for Dami to represent the Chief Justice, well, they might have a point. But in all this, if you ask me, it is needless. It is needless. It is clear that the two gentlemen involved here are both lawyers of good standing. Okay? The former Attorney General's involvement in this case is definitely not without partisan political sentiments. But you see, there was no need for anyone to make reference to the other as being a partisan political representative of anyone. Now, I think this issue came about because the former Attorney General first made reference to certain people who have also in their professional capacity taken up to represent clients before the committee hearing the inquiry into the petitions of the Chief Justice. And he refers to them as NDC lawyers. You know, if you do this, it means you are partisan, you are politicizing the process. You are politicizing the constitutional process that has been initiated. And you don't expect any of them to be quiet. I mean, if you have worked with the Chief Justice and you are a member of the NPP and you became an Attorney General by virtue of your membership of the NPP, and you have defended the government of the NPP before this Chief Justice, and things have happened in the previous court proceedings in the Supreme Court that will suggest to every ordinary lawyer that things were not in the ordinary course of judicial proceedings. And so it is a perception that is already out there that there was some collaboration between the former Attorney General and the Chief Justice in the administration of justice that yielded certain outcomes that were extraordinary in an adverse sense. So you are not the one to start this kind of thing. For me, it's needless. I think I respect the legal professionalism of both of them, though Dami has dragged himself in the mud quite recently. You know, so he shouldn't be the one to start this fight. But be that as it may, if you make reference to a lawyer of a stature as Thaddeus as representing the clients before a committee because of his partisan leanings, when in fact you don't have evidence of those partisan leanings, you know, because you say he is representing the Speaker of Parliament. Now, if I represent the Speaker of Parliament, do I become a member of the NDC? And Thaddeus has been a lawyer for many MPP clients, and that didn't tell you that he was a member of the MPP. So why would his representation of the Speaker make him an NDC by his representation for Ghana at 50 clients and all the rest of and Mala Isa and all the rest of the people who have had serious leanings, fundamental membership of the MPP, not made him an MPP. That is not the way to speak. That's not the way to speak, especially a former Attorney General. But he has done so. And I'm surprised that he is rather surprised at the responses that he's getting as a result of the comments he had made. Because both of them could have made their professional representation of their clients smoothly, without any banter, without any drama. But he started it. And you see, they say he who lives in a glass house don't throw stones. Because when the stones are thrown back at you, not only would you suffer, but your glass will break. You see? So for me, I think it's normal, but it's needless. They shouldn't have gone that way, and the earlier they stop it, the better. Because I believe by now people are talking to them, and I believe by now the tension is getting down. But it is not appropriate for me. I should say it is not appropriate for Fred Dummy to have referred to Thaddeus and the rest of the council as being members of the NDC. You know, so for me, the whole politicization, partisanship in this removal process is unhealthy. It doesn't give good signals and good impression to the people of Ghana. They are following a constitutional process, and you won't focus on the constitutional process. You won't focus on what the allegation, they allege that the woman has done, and you will not focus on challenging what they say she has done, but you are throwing mud at your fellow professionals who have been who are there to represent their clients and to help in the process. Because be that is may, and someone can represent a petitioner without necessarily supporting the case. Because that is professionalism. Because you have to be there to play your role for the truth to come out. The truth comes out, or at least a semblance of truth comes out, when the lawyer does cross-examination or is able to appreciate the other side of the case and take a professional step. You know, so it is actually needless. I think what they are doing is a contest of ego, which shouldn't be. I think they should stop it. But my opinion is that Dami started this, and he shouldn't have started it. He should have just focused on his work as a representative of the Chief Justice at the Committee of Inquiry.
But his opinion was that the coincidences are too many to ignore. That you're seeing, like you said, somebody who represents the Speaker, somebody who has represented the President, that you're seeing them all converging on a case that involves a Chief Justice. That this seems like a whole agenda to force out the Chief Justice. That those things are something that you don't easily ignore like that. Well, what do you think about?
How? So the point is that does the involvement of Thaddeus, Chatuchikata, and Vomowo mean that what is alleged has not been done? Is that what it means? No. Even if the whole NDC teams up against the Chief Justice, but if the allegation is not true, it can happen. And if the MPP teams up in defense of the Chief Justice, but the allegations are true, and the opinion of the committee is that they are weighty enough to warrant her removal, it will happen. You know, so it is just a matter of idiosyncratic leanings. You subjectively prefer a certain outcome does not mean that is the outcome that will yield from the situation. Okay, so even if it is true that these guys, my learned colleagues to who have been referred to as NDC lawyers were true, but the question is, are the allegations true? And if the allegations are true, do they constitute the conditions prescribed by Article 146 of the Constitution, which means incompetence and stated misbehavior? Do they? That's the crux of the matter. And if you leave these issues and you are going after people, and you want the public to understand that it is because the woman was appointed by the previous NPP government that some NDC people are planning to remove her, you take people's mind from the focus, from the trust, the crux of the matter. You know, it shouldn't be so. It shouldn't be so. Even if it is true, as I said, if the allegations are proven and the committee thinks that there are sufficient grounds, they suffice for her removal, she will go. And if she goes, that is right. It doesn't matter who represents her. If Akufo-Addo, the former president, were to represent this woman, but the allegations are true, it will still not yield the outcome that they prefer. And I don't fault anybody for preferring a certain outcome because of your political leanings. Because if you are an MPP, from the trends, the MPP members prefer that, okay, this whole process should fail or should even be stopped for the Chief Justice to continue being the Chief Justice. The other side, and I think majority of Ghanaians, if the research that has been published is anything to go by, want the woman to go. But you see, these preferences are not the issues. I can prefer that she should continue to be. But the question is, does the Constitution prefer that? And how do we know if the Constitution prefers that or not? We go to Article 146 and look at the things that the Constitution says if a Chief Justice or a Superior Court judge does, he or she should be removed from office. Have they been done? If yes, why not? So I think it is neither here nor there. You know, anybody who thinks well will still know that, look, partisan political preferences do not constitute evidence, and partisan political preferences does not constitute the requirement of the Constitution.
Interesting. Partisan political preferences do not constitute evidence. Neither do they constitute the requirements of the Constitution.
No, they are not.
Yes. Okay. Yes. You wanted to make a point.
No. You go ahead.
Okay. I also wanted to bring you back to the matter of Godfred Eboadame, because there are those who also suggest that in his case, the coincidences too are quite a lot. So you can't readily ignore. They point out to one, and I remember you raised that question when we spoke to you earlier when Vincent Esefua had filed his application in court, suggesting that the Chief Justice had not been informed. One of the questions you raised is he suggesting that he's been in communication with the Chief Justice? There are those who go back to that and say Vincent Esefua represented by Godfred Eboadame. Now, the same Godfred Eboadame fails with Vincent Esefua, now goes to now represent the Chief Justice. That particular occurrence alone is worrying, considering the person involved is the Chief Justice. And now the Chief Justice should act in a manner that does not perhaps suggest maybe some either proxy fighting or partisanship alliances among others. Do they have a case when they refer to those two things?
No, you see, perception perception is always, it's a natural phenomenon, given a certain state of affairs. Of course, the fact that Udami, in the first place, is an MPP and was the former Attorney General by virtue of his being the MPP, okay, an MPP member, and his work, his collaborative work in administrative justice with the Chief Justice, okay, and the fact that the Chief Justice was appointed by the MPP government, and the fact that so many decisions have been perceived by the public to have gone in favor of the MPP government just because the Chief Justice was presiding or is the Chief Justice at the time. All these things come together to create a certain impression in the minds of people. But as professionals, those perceptions should be allowed to be practiced or exercised by the public. But as professionals, we shouldn't wade into that, because no bundle of perceptions will ever constitute proof or evidence of anything. Yes, even if it is the case, okay, yes, an MPP member is fighting for an MPP member in a constitutional battle. But why make reference to it? Even if it is coincidence, or the coincidence is so glaring, what does it change? It won't change anything. The point is, the facts that have been alleged must be proved, and if they are proved, no partisan political preference can take precedence over what is proven and over what the Constitution requires to be done to the proven facts. It's as simple as that. It is as simple as that. But the point is that, for me, my opinion is that Dami rather has a lot of factors on which anyone can properly perceive him to be fighting a partisan political battle. He has more of that than all the three. Because for me, the fact that you represent a client, Professor Thaddeus had represented a lot of these NPP guys before. And he has fought. Thaddeus has represented the former Chief Justice. You remember?
Yes.
Yes. Thaddeus has provided legal service to the former Chief Justice, Eni Yabua, before. Does that make him an NPC? Does that make the court he was fighting a partisan political battle? No. You see, so the mere representation, the mere fact that someone represents a person who is a politician should not have been the grounds, per se, for the former Attorney General Godfred to make reference to them as NDC lawyers who have teamed up with an NDC agenda to remove the Chief Justice. You see, meanwhile, you have more cobwebs, more factors on your side to suggest that you are doing partisan political fight on behalf of the NPP. So it is not proper for you to want us to think that you are fighting on principle, but the others are issuing a partisan political agenda. For me, there's nothing in history, especially if it comes to Thaddeus. For me, even initially, I perceived Thaddeus, and I've never said this, I perceived Thaddeus to belong to the other side. And now others are thinking he belongs to the other side, which tells you that he probably is neutral. He's objective. But on your side, I haven't seen Godfred represent any NDC member in any partisan political matter. Never. Okay? And we have also seen that even you don't just represent or fight the partisan political matters, but also historically, we have noticed that almost all the matters involving partisan political matters have gone in favor of the ruling government. And a lot of the things Thaddeus had referred in his writing, and I'm saying that all these things were needless. And I believe Thaddeus wouldn't have made reference to them, but for the fact that Dami has referred to him as an NDC lawyer who is pursuing an NDC agenda to remove the Chief Justice. In the first place, if they hold you to account, if they hold you to strict proof that this removal process is an NDC agenda, what will be your evidence? What will be your evidence? So for me, I think the whole issue, they should let their attention go to the allegations, the facts that have been alleged, and the evidence that have been given in proof of the facts that have been alleged. Now they should come and tell us that all the facts that have been alleged against the Chief Justice are not true. That is what we want to hear. Or, okay, if you even want to say that, okay, they are true, but we don't think they are grievous enough to warrant the removal of the Chief Justice. Because sometimes when you listen to them, that's what they try to say. That because if someone says the removal of the Chief Justice shouldn't be that easy, what the person is actually saying is that, okay, even if all the things they allege against her have been proven against her, it still should not be the grounds for her removal. Now, that's a different conversation we can all engage in. And we can compare that to historical events. Because for purpose of fairness, it is not for nothing that in law we make reference to precedent. Because it's part of fairness to do same or to do similar things to similar facts. Because if someone does something of similar weight, who occupies that office and lost that office because of that thing, we cannot say that another person who has done similar things should not face the outcome of the law as the others have, because that would not be unfair. That would be unfair. That would not be fairness. And so it is a matter of fact and matter of evidence, and actually matter of moral and legal evaluation of those things. It is not a personal attack. It can be true that, okay, it can be true that, or it may be true that someone wants to remove the Chief Justice. But the question is, if the person wants and the Chief Justice has not done what the Constitution has prescribed, would the person be able to remove the Chief Justice? The question is no. The point is that it is not everybody who wanted the former Chief Justices. It is not both parties. It's not all the parties who wanted the former Chief Justices that have passed to have been in office. Yes, because sometimes some people will wish that they have a ground to remove them, but they never had. Some never had against them, and some had, and perhaps it didn't go their way, and they remain the Chief Justice until they finish. And the point is that why, you see, I always say that, look, every argument against this process is always motivated by a certain predetermined outcome that we don't know. What if this woman, after the whole process, is absolved and she remains the Chief Justice? Wouldn't they be shy about the things they are doing and saying against the NDC? Because it's a matter of facts and evidence. If the committee goes through it and say, oh, we don't find, if their recommendation and report to the president is that no, she should remain the Chief Justice, we don't find this grievous enough, or some of the allegations are not true, what would they say? Will they now go back to the public and say, oh, we were wrong when we said, or what? You know, I expect some of these things to be coming from the non-legal public, people who have no familiarity with the law. But for a former attorney general, to leave all the facts, all the legal issues, all the constitutional issues, and launch attack against the persons and the motive, unproven motive of his own colleagues. It's unacceptable. That is unacceptable, and that is unprofessional. And so, if he gets that in a similar, if he gets that back in retaliation, well, I think it serves him right. But for me, I think it is enough. At least the public has come to know that this is what is happening, and this is not important. It doesn't serve any useful purpose in this process. Personal attacks will not serve any useful purpose to this process. And whatever the Constitution requires to be done, if it is proven, that is what will be done, irrespective of anybody's partisan political preference.
Well, there's one thing that Godfred said in that interview with Joy News that cannot be ignored. That is that he feels this is what is happening in the case of the CJ is an attack on the judiciary, and that's why it is gotten involved. That there is an attack on the judiciary with this process, with what he also says he sees as unfairness in the way this process is being conducted. Does taking the CJ to this process alone amount to an attack?
Of course not. And that's why I said, you see, the professionalism is not being allowed to play out here. Because the lawyers, in fact, if this is what Dami said, it is clear that he has allowed his emotions to soil his professional ability and focus. Because if he says this, then it means he's not being professional. Because, hey, there are chief justices who have gone through these processes and survived before. The Constitution itself has made provision for the removal of a chief justice and a member of the Superior Court. So, how can that be an attack on the judiciary? The question is, then even that statement that is an attack on the judiciary is in itself prejudicial, because he's saying that the allegations made against the woman are not true, while in fact the committee is still inquiring those allegations. If you don't think they are, if you don't come to the conclusion that they are false, why would you see that as an attack on the judiciary when you know that they are following a constitutional process? For me, it is whether the facts and allegations and evidence are proven. The facts are proven by the evidence, then that is all. In any event, the Chief Justice as a person is not the judiciary. And she is the head of the judiciary, but that is not the judiciary. The judiciary is bigger and broader than that. And the removal of Justice Tokono from office does not mean the judiciary is no more. Okay? For me, and those who think that this affects judicial independence because they think that it is an attack, the point is that this is warning the judiciary that there is an accountability provided in the Constitution for them to go through. And so it is not, the Constitution hasn't created judicial tyranny. Judicial tyranny. You can't create an institution and give it a carte blanche to do whatever it likes. No constitution, no government, no state, no country does that. The judiciary is sacrosanct. We know that. But the Constitution is more so. And if the Constitution creates you and wants to take you through an accountability process by saying that if you do ABC, you will lose the office. And someone alleged that you have done ABC, and this is not the first time that those allegations have been made against any Chief Justice. We know that such allegations have been made against Aban before, Uredu, Justice Aqua. So if and they've been made against any Yabua. You see? So why would this be construed as an attack against the judiciary or any affront to the independence of the judiciary because it is Justice Tokono or because it is the Chief Justice? I mean, I don't get it. I don't get it because unless the people who are arguing this way think that we should scrap the whole of Article 146 because it's Article 4 and as a Chief Justice, she should be removed. This is what the Constitution says. Now, if the Constitution says that, how can the implementation of this part of the Constitution now be construed as an affront to the independence or as an attack to the judiciary or the independence of the judiciary? I don't get it. I think all those who say this are saying that out of partisan preference, partisan inclinations, and idiosyncratic thinking. Otherwise, you will allow the process to go through. And if the argument is that the allegations are not true, then we can listen to you. If the allegations are not true, we can listen to you. If the allegations are true, if you admit they are true, and you want us to believe that it's not grievous enough to warrant your removal, we can listen and engage ourselves in that debate. But you don't say that the whole constitutional process is in itself wrong when the inquiry is still going. And now it has even gotten to the point where a clear prescription of the Constitution is being asked to be violated in preference of the Chief Justice. The Constitution says this whole process should be done in confidence, should be done in camera, which means it should not be published. It should not be public. It should not be, presented to the public. Yet, our Chief Justice, who has taken a judicial oath to protect, preserve, and defend the Constitution, is now saying that provision which says it should be private, it should be in camera, it should be confidential, should be set aside, and the process should now be public. How? How can this be consistent to your judicial oath? And even that statement alone is an overthrow or an attempt to overthrow a provision of the Constitution. Now, the reasons given for this to happen is that constitutional provision is for the purpose of protecting the Chief Justice. And so she has the right to waive it. Why? Why do we even go to the motive, to the purpose of that? Because the interpretation of Constitution is that you go by the literal meaning. If it is clear and unambiguous, you don't try to interpret it by imputing any motive or intention to it. If the words are clear and unambiguous, the express words should be taken to be the intention of the framers of the Constitution. Don't make it public. Is it ambiguous? Is it unclear? Why should we go into it to now find the purpose? The purpose is that it wants to protect the rights of the Chief Justice, and we go ahead to impute another meaning that, okay, once it's for her purpose, then she can waive it. That are two very, very, very heinous statements.
Is that consistent with her description of herself as a textualist? Because that's what she says she is. Is that argument consistent with what she says she is?
Yes, of course. Her statement that the law is the law has made everybody believe that she is a positivist. We say in law, she is a positivist. She believes in what is posited in the law. Now, if the law is the law and the law says, let the thing be in camera, why is it now not the law? Because you are involved. You see? And now you allege breaches of fundamental human rights and say they should stop the proceeding because of those breaches. Meanwhile, you and I know that those fundamental human rights provisions are not to be enforced in the Supreme Court. They are exclusive preserve of the High Court for enforcement. Then you go to the Supreme Court with those provisions, and you are the Chief Justice. You know, those are the things. Because they allege a breach of Article 19, they allege a breach of Article 17, they allege a breach of Article most of the alleged allegations they've made in this their new suit border on fundamental human rights. They allege a breach of Article 23. All these things are fundamental human rights provision in jurisdiction. Cannot do that at a court of first instance. That you go to the Supreme Court and seek direct interpretation of fundamental human provisions and then enforcement, because they can't divorce interpretation from enforcement. Because when the Supreme Court makes a declaration, it is an enforcement of the fundamental human rights provisions or the constitutional provisions. Whichever constitutional provision you allege has been breached, if you take it to the Supreme Court and say it means this, and so they should make this declaration, you are asking for both interpretation and enforcement. And the enforcement is for the Supreme Court, if the provision is fundamental human rights provision. So these are the things that, for me, I think the Chief Justice should have just calmed down. Should have calmed down. The process, you see, they should do away, purge themselves of the perception that they want her removed, purge themselves of the perception that the committee proceedings are iron necessity, that are without that are moving, you know, towards an inevitable result, and that result is the removal of the Chief Justice. No. They should focus on the allegations, and they should focus on matching that to the constitutional prescriptions or requirements. Yes.
Two things, so that will bring this to a close. One is, I wonder, because the most recent history is Charlotte Osei. I think that Article 146 applied in her case. Now, to what extent would her precedence be important in coming to a conclusion on this matter? Because I recall the reason she was taken out and her two deputies followed had to do with procurement breaches. To what extent would her precedence be applied in this situation?
You see, that's why I'm saying that we are not there yet, and they are not clear about their position. They are not clear about their position because we don't know if they are saying that the allegations against the Chief Justice are true, but even if they are true, they are not grievous enough to warrant a removal. No, we are not clear about that. But if you listen to all they are saying, now at one point they think they shouldn't have found prima facie case, which means the allegations did not warrant even an inquiry, a response. Now at another breath, they tell you that no, the Chief Justice removal shouldn't be that easy, which means that the allegations made against him, even if proven, should not be the grounds for a removal. Now this is where Charlotte Osei's issue came. Now, but why do we refer to Charlotte Osei's case when she is not a judge? It is because of the same Article 146 and the constitutional provision that made the office of the Electoral Commission put the member of Electoral Commission at the status of a Court of Appeal judge. And Court of Appeal judge is a superior court judge. I mean, this needs to be said for the understanding of the public. You see, and so it became necessary for Charlotte Osei to now be taken through Article 146 for a removal. But now let's look at you asked the question. When Charlotte Osei was going through this process, and after she was removed, after the process, I personally wrote an article which was published even outside this country, I guess.